Welcome to Part 1 of the Guardianship Workshop. This workshop is presented by the Superior Court of California, Santa Clara County Self-Help Center and Family Law Facilitator's Office. The contents of this workshop are intended for informational purposes only and do not constitute legal advice. If you need legal advice, please contact a private attorney. During this workshop, we will go over what is a guardianship, common terminology, temporary versus general guardianships, and will provide an overview of the court process. Note that this workshop will cover guardianship over the person only. Guardianship over the estate, where a person is appointed to manage a child's property, such as money they may have inherited, will not be covered. After this workshop, you will be directed to complete the necessary forms to start a guardianship case in Santa Clara County. A probate guardianship gives the guardian, who is a non-parent caregiver, custody and decision-making authority over a minor child. For example, a guardian may enroll a child in school, add the child to their health insurance plan, consent to the child receiving medical care, and apply for public benefits on behalf of the child. A guardian also has the discretion to decide who the child has contact with, although the judge may make specific orders about the child having contact with their parent or parents. A guardianship does not terminate a parent's parental rights. It only suspends them while the guardianship is in place.
It is important to distinguish a probate guardianship from other types of court proceedings. A guardianship is not a juvenile dependency proceeding where a child may be removed from the home due to allegations of abuse or neglect by the parents and which may result in the parent's rights being terminated. A guardianship is also not a family law proceeding where decisions about custody and visitation between a child's parents are made. And a guardianship is not an adoption proceeding in which the parent's rights are terminated and a new legal parent-child relationship is established between the child and the adoptive parent or parents. A guardianship is also not an informal caregiving arrangement where a child may live with a non-parent but the parents still retain custody. In an informal situation such as this, the caregiver may qualify to sign a caregiver's authorization affidavit so that they may consent to the child receiving medical care. You must be a qualified relative as defined on the form. The child's parents do not need to sign the form, but you must inform them of your intentions or be unable to locate them. This form does not get filed with the court. This form is not likely to be sufficient if you wish to add the child to your health insurance or enroll the child in school. You are likely to need a guardianship for that.
The term petitioner refers to the person who files the petition and other court paperwork. Usually, the petitioner is the proposed guardian, but this is not always the case. The child themselves may instead be the petitioner if they are age 12 or older. Another interested person may also be the petitioner. The term guardian refers to the adult who is granted guardianship over the child. The guardian is often a relative of the child but can also be an unrelated person. If more than one adult is appointed guardian, then they are called co-guardians. The term ward refers to the child who is the subject of the guardianship. A guardianship will automatically terminate when the child turns 18. A guardianship may also be terminated before the child turns 18 if the judge determines that doing so is in the child's best interest. If the guardianship is terminated before the child turns 18, custody typically reverts back to the parents. Note that in cases where the minor is seeking a type of immigration relief called special immigrant juvenile status, the guardianship may last beyond the young person's 18th birthday. The type of guardianship that lasts until the child turns 18, unless it is terminated prior to then, is called a general guardianship. A temporary guardianship is one that lasts only until the hearing on the general guardianship. You can never seek a temporary guardianship only. It must always be accompanied by a petition for general guardianship. When completing your forms, you will need to decide whether you want to request a general guardianship only, or whether you want to request both a temporary guardianship and a general guardianship. You should decide this based on how soon you need court orders giving you custody of the child.
When thinking about how soon you need court orders giving you custody of the child, consider factors such as this. How soon do you need to add the child to your health insurance, get the child medical or dental treatment, apply for public benefits on behalf of the child, or enroll the child in school? If you request a general guardianship only, the soonest you would get court orders giving you custody of the child is approximately 10 weeks from when you file your forms. If you request a temporary guardianship also, you may get temporary orders giving you custody of the child in only about 3 weeks. Note that if this is an emergency and the child's safety or welfare is at risk, you may qualify to get court orders on an expedited basis within 2 to 3 business days. For more information and immediate assistance, please visit the Restraining Order Help Center. An overview of the court process to obtain guardianship is as follows. Step 1. Fill out your forms. Please see Workshop Video 2 for a description of the forms you will need to complete. Optional Step 2. Have the Self-Help Center staff review your forms for you before you file them. To do this, email your forms as a PDF to shcprobate@scscourt.org. Step 3. File your forms at the probate clerk's office in person or electronically. Step 4. Arrange for filed copies of your documents to be served in the child's parents and others entitled to notice of the proceedings. See Part 3 of this workshop for more information about service. Step 5. The court investigator will complete background checks, interview parties, and gather information. Step 6. Attend your court hearing or hearings.
This concludes part 1 of this workshop. You are now ready to complete your forms. You can find the form packets by going to the self-help section of the court's website or by clicking the first hyperlink on this slide. Another option is to use Odyssey Guide and File, which is an electronic form program that allows you to enter in your information and it will populate the forms for you. Then, go on to part 2 of this workshop to learn about the forms you will need to fill out.